389th District Court right now.
Oh, okay. All right. So
You can ask the state.
all right, state, Mr. Nguyen, good morning.
Good morning, Judge.
On what was her name again? Claudia Requenes.
Yes, Judge.
I understand there's an agreed order for the competency test.
Yes, Judge, but we never got it back from the court whether they approve of the competency evaluation or not, Judge.
Okay. So we're gonna go that route instead of a bench trial,
But that's what defense counsel would want,
right?
Judge.
With Ted Lopez.
Yes, Rachel, can you follow up on that, please, to make sure the order comes up? I don't think we ever saw the order, Mike, and nobody called us or followed up with us.
Okay.
But-
That-
But
that's
we'll look at,
I do see that there's an order, but it didn't have the signatures from the DA or the attorney.
okay. All right. So then, is this the only jail case we have today?
Yes, Judge, it's the only jail case. Yes, sir.
Okay.
Yeah, that's it. She can-
Okay, so then on Claudia Requenes, CR 21-13-838D, CR 21-13-839D, we'll go ahead and reset that matter for a future date because we're going to be doing an incompetency test.
Judge, if you could invite the witness in, because I mean the judge, the witness should be waiting in the wait room, hopefully.
There's a witness?
Oh, there's like a whole lot of witnesses, Judge.
Okay. Then,
I need names.
yes, could you give us names so that we can,
Sure, Judge. The victim, Eloy Manchaca, Officer Belen Ganoa.
Eloy Menchaca?
Yes.
Who's the second one? Belen?
Belen Gayanoa. That's an officer.
Gaona. Okay, Gaona. Okay.
Gaona. And Lieutenant Easton.
Lieutenant Easton. Okay. Uh-huh.
And Officer Daniel Gonzalez.
Officer Dan Gonzalez.
Yes. And Officer David Balboa.
David Balboa.
And maybe
The officer-
I'm not sure if there's one more witness, Julissa Vasquez.
Yulisa
Vasquez.
Vasquez.
Okay, I have David Balboa and
Okay.
Robert.
Well, then, for the purposes of the jail, let me go ahead and excuse them. We'll go ahead and get another reset date on Miss Claudia Requenes.
Listen,
Okay, so-
hello, can I talk? Can I talk? Because I don't know what you're talking about, really. You are talking about other things, I don't know. I just came here for 2 charges for Church's Chicken case. My Church's Chicken case is one for assault and one for and another one for trespassing. Those are the 2 charges I have. And you're talking about something else. I don't understand.
I'm not talking about anything else. I'm just saying goodbye. I'll see you later. I'll give you another date. Thank you, Jill. Bye-bye.
When? Because I've been here 4 months. I cannot wait too long. I had to work.
All right. Thank you, Jill. Bye-bye.
Thank you. Then you can be have my house clean.
All right.
We have
Court-
both officers.
Court will resume with the April 11th, 2022 docket. And at this point, we're going to be excusing potential witnesses for today's bench trial. Have you done that already?
They're on the screen, the officers.
Okay, they're on the screen right now. Okay, Mr. Officer Balboa, I think you're one of them. We will not be needing you this morning, okay, sir? You're excused.
And please contact the state.
Yes, Balboa. Okay? Thank you for waiting. Thank you. Who else is gonna go?
What are the other names?
I've got Eloy Menchaca, Belen Gaona, Lieutenant Easton, Yulisa Vasquez, Dan Gonzalez. I saw Easton somewhere in there.
And I brought him in, but I guess he disconnected.
Okay, he disappeared. Okay. I don't see anybody else. Yeah. That's
I
it.
guess that
Yeah.
when they come in.
Yeah, we don't recognize any more names on the screen, so if we do, I guess we get them out one by one. All right, what's next?
Okay, Judge.
Jailhouse.
My name is Jonathan, Sherilyn Quayle,
I think she's-
right there, is Quayle right there. There's two cases state for Sherilyn Cuellar. It'll be a plea on both of them.
For Sherilyn, yes, Judge.
CR 2010-348, CR 2010-861, Sherilyn Cuellar. It'll be both pleas, right?
Yes, Judge.
All right, both pleas. Let me just get her on.
She needs to unmute and she makes video.
All right, good morning, Mr. Ramirez.
Morning, Judge.
Mr. Eason.
We're waiting on,
He can be released.
okay, Mr. Easton. Good morning, sir. Can you hear me? You're excused for right now, okay, sir? We don't need you this morning, okay? We'll let you know later on if we do need you. Thank you so much for waiting. You're excused. Have a great day.
Lieutenant.
Waiting on Sherilyn Cuellar to unmute. And we need some video. Mhm.
You need to tell Ted Lopez that the order is not signed.
Where's
He's
Mr.
coming
Lopez? Oh, okay. Okay, we have an agreed order for mental competency test, but it's not signed, right?
Correct.
Needs to be signed by everybody? All right. Mr. Lopez, good morning.
Good morning, Your Honor.
Your case, I know, let me see here. Give me a, oh yeah, Claudia Requenes,
Yes, Judge.
CR 21-13-838D, CR 21-13-839D. I understand there's an order for a competency test?
That's correct, Judge. I did file it on one of the cause numbers, the assault charge, Judge. Both of these cases stem out of the same transaction, Your Honor. I
Okay.
believe if she's found incompetent in one, she'll be found incompetent in the other case, Judge. So we're just urging that at this moment.
Okay, and so I understand there's an order already in place, but it hasn't been signed yet, so it has to be signed by all the parties. Okay,
Yes, Your Honor.
so we're gonna find it, then we're gonna move it around.
So
Ted,
do
if
we
you
need
can-
we need another order that needs to be signed, or?
Did you guys ever sign an order for the court? If it's agreed to?
I never
had
got a
some-
copy of it.
Okay, I had submitted one. Apparently it wasn't, it was accepted, but it wasn't the one that the court was looking for. I submitted another one, Judge, but if it hasn't, I'll send another copy to Mr. Gwynn right now, so it can be taken care of.
Mr. Lopez, if you could submit for both cases, so, because my admin required for Dr. Pena required both for both cases. We're gonna evaluate her for both.
Okay, that's not a problem. I'll prepare them and I'll send them, and then you'll file them, Mr. Gwynn?
I'll do it, yeah.
Okay.
Send to me.
Okay,
Mike,
Take a-
is that order gonna be suffice or do you have to file your order from your office?
Well, I'm gonna file that order and the court gonna say that, they're gonna grant competency hearing, then, we're gonna have another order sending into appointing Dr. Pena.
Okay,
Well-
we don't need to have a competency hearing. This is it. I mean, the
Right.
court's gonna
We-
grant it. All we need is just the order so that the judge can sign, so you guys can get an appointment
right,
with Dr. Pena.
right, yeah,
That's
we need
right.
that order for Dr. Pena, that's what I'm trying to say. Okay,
And that's from the state. That's something the state takes care of, correct? The
Well,
order
first
Dr. Pena?
we need one from the defense counsel saying that to suggest incompetency.
But the order agreeing, that's
That we
my
need it.
confusion, because I filed a motion for competency with everything that was necessary, an order granting with everything necessary, but apparently I needed to submit something different, which is what I had submitted, but
Right now, we
That's-
just,
okay, just, I'll sign the order for the, that we need it.
and Your Honor, I
then,
filed one in February 25th, Judge, and then I filed another one March 22nd. And so I don't know if the court could review and see if those are sufficient. If not,
So, Ted-
yes,
You already filed your motion, to asking the court for a competency hearing, correct?
yes, I filed a motion February 15th or so.
Okay,
So now we just need the order from Mike's office.
well, we need the order that, to grant the incompetency first.
Ted,
That needs to
submit
be
an
signed
order,
by,
submit an order for the court to sign saying we need one, okay? We need a competency test,
okay,
okay?
okay, Judge, I'll submit with my signature and.
And
place for
include
Mr.
both,
Gwynn.
include both cases.
I mean,
Yes, Your Honor, I'll
we'll
do
talk
that.
about this after docket, Mr. Lopez. If you need any questions, feel free to call me.
Okay,
All
all
right,
right, thank you, Judge.
Thank you, bye-bye. All right, it's Monday, guys. It's Monday. We're getting there. We're just getting started. I just turned on the engine. The wheels of justice are beginning to turn. Mr. Ramirez, you're here on Cuella?
That's correct. Sherry,
Len Cuella.
that's correct.
Okay, it'll be a plea on both cases, right?
That's correct, Judge.
All right, let's get started here, man. Ms. Cuella, can you hear me?
Yes.
Good morning.
Good morning.
All right, please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Two cases, man. We have both of them are Class B misdemeanors. Both of them are possession of marijuana cases. CR 20 103 48D, CR 20 108 61D. Each case a Class B misdemeanor. Each case carries a potential penalty of up to 180 days in jail and not more than a $2,000 fine upon conviction. You understand that?
Yes, I understand that.
You,
Judge.
you understand that you're entitled to a jury trial, you're entitled to an appeal, and that you waived those two rights?
Yes, I understand that, Judge. He froze.
Morning, Jessica.
He's froze.
Morning.
Chantel, morning. Rachel, Rick,
Good morning.
you're muted, Judge.
You're muted, Judge.
All right, thank you all.
Oh, he froze again.
All right, Ms. Cuellar,
Yes, Your Honor.
you're entitled to a jury trial. You're entitled to an appeal. That you waived those two rights?
Yes.
Have you ever been declared mentally incompetent?
Yes.
Have
No,
you ever been
sorry.
declared- Okay.
I'm
All
so
right.
sorry.
All right, you understand that the court does not have to follow the recommendations when you give a plea?
Yes.
All right, what's your plea, ma'am? Guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily on both cases?
Yes, Your Honor.
All right, state.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification of defendant right of appeal as Exhibit 2, waiver of Article 9.14 disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4. State would also request defense counsel to stipulate to the venue and jurisdiction of this honorable court, and to also stipulate that evidence has been filed sufficient to culpably plead guilty.
No objection, so stipulate, Judge.
Without objection, so admitted. It'll be the judgment of the defendant is guilty as charged on both cost numbers. Recommendations, do they happen to be identical?
Yes, Judge, they're identical, Judge.
And what is it?
Judge, the state recommend $100 fine, court costs, 90 days in the Delaware County Jail, probate for 10 months, and the defendant to participate in to outpatient, Judge.
Okay, $100 plus court costs, 90 days in jail, suspended and placed on 10 months probation.
Yes, Judge.
And then what else? The outpatient?
Yes, Judge.
All right, that's for both cases, right?
Yes, Judge.
All right, then on the second case, CR 20, on the first one, CR 20-103-48D, that'll be the judgment. And then the second one, CR 20-10-861D, no fine, no court costs, no fees. And it'll be the same thing, 90 days in jail, suspended and placed on 10 months probation, and then the outpatient program. Is that the understanding, Mr. Ramirez?
That's correct, Judge. And that'll be one supervisory fee as well, correct?
Yes, one fee only. All right, that'll be both judgments. You may be excused, Ms. Cuellar.
Chair has Jonathan.
All right. Good luck with your probation, man. Bye-bye. Jill?
Yes, Jonathan. I don't know if that's the gentleman right here.
All right, Jonathan. Give me a number, number 6.
He's got
Jonathan.
Number 2, number 5, and number 6.
Okay. 2. Is it 5 and 6? Okay, next case is going to be Jonathan Garcia Delgado?
Is that him?
Delgadillo.
Yes.
Delgadillo. All right, there's 3 cases. How many pleas, state?
2 plea, Judge, and the 1 dismissal, Judge.
All right, I think I got him already. All right. Please raise your right hand, Mr. Jonathan. Can you hear me, Jonathan?
Yes.
All right, good morning, sir. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes?
Yes.
You may put your hand down. Okay, it's going to be a plea on 2 cases and then 1 dismissal after that. The 2 cases, CR 20-09-424D, Jonathan Garcia Delgadillo, Class A misdemeanor, unlawfully carrying a weapon. And then CR 21-00-412D, Jonathan Delgadillo, DWI Class B misdemeanor. On the Class A, the potential penalty can be up to a year in jail and not more than a $4,000 fine upon conviction. On the Class B DWI, the potential penalty can be up to 180 days in jail and not more than a $2,000 fine upon conviction. You understand that?
Yes.
You understand that for each case, you're entitled to a jury trial, you're entitled to an appeal. Did you waive those 2 rights?
Yes.
Have you ever been declared mentally incompetent?
No.
You understand that the court does not have to follow the recommendations after you give a plea?
Yes.
And what is your plea, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily on both cases?
Yes.
All right, state.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification of defendant right of appeal as Exhibit 2, waiver of Article 9.14 disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4. State would also request defense counsel to stipulate in the venue and jurisdiction of this honorable court, and to also stipulate that evidence has been filed sufficient to culpably plead guilty.
No objection, so stipulate, Judge.
Without objection, so admitted. It'll be the judgment of the court. The defendant is guilty as charged on both cost numbers. Recommendations here, state, beginning with the DWI case, CR 21-00-412D. What is it, sir?
Yes, Judge. The state recommend $250 fine, court costs, 180 days in the Delaware County Jail, probate for 1 year, an alcohol course, a drug education course, 2 months drug patch, 90 days taxi driverless suspension, and 20 community service hours.
20 community hours. Let me hear the second recommendation. That's going to be on CR 20-09-424D.
Yes, Judge. The state recommend $100 fine, court costs, 6 months deferred, a gun safety course, and the forfeiture of the weapon, Judge.
Gun course and then forfeiture. Okay, on this one, CR 20-09-424D, it'll be the judgment of the court that the finding of guilty and all further proceedings are hereby deferred. So it'll be deferred. And this one, no fine, no court costs, no community hours, 6 months deferred gun course, and forfeiture of the weapon. And then on this first case, 250 plus court costs, 180 suspended for 1 year, alcohol classes, the drug classes, 2 months worth of patch, 90-day suspension of driver license to run concurrent with any administrative suspension, and court will hereby waive the community hours. No hours. Did you get that, Mr. Ramirez?
Yes, Judge. So for the unlawful, the fee and the court costs were waived, is that correct?
Yes, sir. And the
once
fees.
Well, okay.
Yeah, no fees, no court costs, no fines. They're gonna run concurrent. And then we have a third case, state.
Yes, Judge, on CR 21-01-888D, Judge, that will be dismissed with the aforementioned plea, Judge.
Court will hereby dismiss CR 21-01-888D, State versus Jonathan Delgadillo, case dismissed.
Okay, and we're also submitting a motion for the weapon.
All right, very well. That'll do it. We'll await the motion. Anything else?
No, Judge.
All right, Jonathan, good luck with your probation, sir. We'll see you later. Thank you, sir.
Thank you.
Thank you, bye-bye.
Thank you, Judge.
Yes, sir, you may be excused.
Number 11.
Number 11.
The PTD.
All right, good morning, Mr. Almanza.
Good morning, Your Honor.
Your case, CR 22-00447D, Valentin Martinez.
Yes, Your Honor. He's going to be entering PTD POM today.
It'll be a PTD POM, you got it. All right, he needs to unmute. PTD POM. All right, can you hear me, Mr. Martinez?
Yes, sir.
It'll be a plea for a PTD POM, okay, sir?
Yes.
Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes?
Yes.
All right. Thank you, sir. CR 22-00447D, Valentin Martinez, your charge, Class A misdemeanor POM. It carries a potential penalty of up to a year in jail and not more than a $4,000 fine upon conviction. You understand that?
Yes.
You understand that you're entitled to a jury trial. You're entitled to an appeal. Did you waive those two rights?
Yes.
Have you ever been declared mentally incompetent?
No.
You understand that the court does not have to follow the recommendation after you give a plea?
Yes.
And what is your plea, sir? Guilty or not guilty?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes.
All right, state.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification of defendant right of appeal as Exhibit 2, waiver of Article 39.14 disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4, PTD POM pack at Exhibit 5. State would also request defense counsel to stipulate in the venue and jurisdiction of this honorable court, and to also stipulate that evidence has been filed sufficient to prove a plea guilty.
So stipulated, Your Honor.
Without objection, so admitted. It'll be at this time, the court will withhold any finding of guilt or innocence and will suspend any judgment whatsoever in this matter, and will now turn to the PTD program, which has already been approved and signed by all the parties involved here. All we ask here, Mr. Martinez, follow the terms and conditions of the PTD packet, and hopefully down the line, this case will get dismissed. We need a status hearing for December 7th. December 7th at 9 a.m. December 7th, 2022, 9 a.m. for a status report. Hopefully we'll get a good report. And like I said, down the line, we'll hopefully dismiss the case. Any questions, Mr. Almanza?
No, Your Honor, I don't have any questions at this time. If my client does complete all the requirements within the 60 days, then we could possibly just get this administratively dismissed, I would assume.
If any time between now and December 7th, you and the state can get this dismissed administratively, the court will approve that, okay?
Thank you, Your Honor.
All right, you all stay safe and you get your excuse. Good luck, Mr. Martinez. All right, bye-bye.
Okay, number 7, Mr. Carlos Garza.
Okay.
I don't know if that's his client, Maria.
Well, let me see here, Mr. Carlos Garza. Good morning, sir.
Good morning, Judge. Yes, it is. She's there on Moto G Stylus.
Oh, that's her. Okay. Yeah. Moto Stylus. Okay, very well.
She needs to unmute.
And she needs to unmute. That would be Maria Hernandez, right?
There she goes. There she is.
All right. It'll be a plea, Mr. Garza?
Yes, sir.
All right. Good morning, Ms. Hernandez. Can you hear me?
Yes, sir.
Okay. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. CR, you can put your hand down and put it back in the steering wheel, okay? CR 21-05508D, Maria Hernandez, your charge DWI, Class B misdemeanor. It carries a potential penalty of up to 180 days in jail and not more than a $2,000 fine upon conviction. You understand that?
Yes.
You understand that you're entitled to a jury trial. You're also entitled to an appeal. And did you waive those two rights?
Yes.
Have you ever been declared mentally incompetent?
No.
You understand that the court does not have to follow the recommendation when you give a plea?
Uh,
Yes.
Can you? Yes.
Okay. And how do you plead, ma'am? Guilty or not guilty?
Guilty.
And are you pleading guilty freely and voluntarily?
I didn't understand the question. What was it?
Are you pleading guilty freely and voluntarily?
Yes.
Okay, there you go. State.
Yes, Judge. State offer plea document and offense report as States Exhibit 1, notification and certification of defendant right of appeal as States Exhibit 2, waiver of Article 9.14 disclosure as States Exhibit 3, waiver of risk and need assessment as States Exhibit 4. State would request the defense counsel to stipulate in a venue and jurisdiction of the normal court, and to also stipulate that evidence has been filed sufficient to plead guilty.
No objection, so stipulated.
Without objection, so admitted. It will be the judgment of the court that Maria Hernandez is guilty as charged in CR 21-05508D. Recommendation, state.
Yes, Judge. The state recommend $300 fine, court costs, 180 days in the Ogden County Jail, probate for 10 months, an alcohol course, an interlock ignition device, 90 days sexual travel suspension, and 20 community service hours.
20 community hours. All right. Yes, sir, Mr. Garza. Is that the understanding, sir?
It is, Judge, but as far as the Garden Interlock is concerned, my client is a 45-year-old U.S. citizen. She's a provider. She works from 9 to 6:30. It's her first DWI, and she didn't blow past a .15. We're asking if that could be taken off.
Okay. It's not mandatory, in other words.
That's correct.
All right. Court will hereby waive the community hours, 20 hours. That'll be waived.
Thank you.
We'll waive the interlock device.
Thank you.
So therefore, we're sticking with the recommendation from the state, okay? $300 fine plus court costs, 180 or 10 months, and the alcohol classes. 90 days suspension of driver license to run concurrent with the administrative suspension. Anything else, there, Mr. Garza?
That's all I have, Your Honor. That's
okay, Ms. Hernandez. Good luck with your probation, okay, man?
Yes.
All right, you stay safe, and good luck with. Bye-bye.
Thank you, Judge. That's all I have.
Thank you. Your excuse.
Thank you.
Number 10, Mr. Carlos Ortegon.
Mr.
Haley Vasquez.
All right, number 10, Mr. Ortegon. There he
Good
is.
morning,
There.
Judge.
Oh, good morning, sir. Your client, Haley Vasquez?
She should be on there, Judge.
Yes, there she is. She needs to unmute. All right, can you hear me, man?
Yes, sir.
All right, good morning. There'll be a plea, right, Mr. Ortegon?
Yes, Your Honor.
All right. Ms. Vasquez, please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may put your hand down. CR 22-00331D, Haley Vasquez, your charge, Class A misdemeanor, failure to ID. It carries a potential penalty of up to a year in jail and not more than a $4,000 fine upon conviction. You understand that?
Yes, Your Honor.
You understand that you're entitled to a jury trial. You're entitled to an appeal. Did you waive those two rights?
I'm sorry?
Yeah.
You are entitled to an appeal, and you're also entitled to a jury trial. Did you waive those two rights in writing?
Yes.
Okay. Have you ever been declared mentally incompetent? Crazy, but a doctor or anything like that? No? How do you plead, ma'am? Guilty or not guilty?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
All right, state.
Yes, Judge. State offer plea document and offense report as States Exhibit 1, notification and certification of defendant right of appeal as States Exhibit 2, waiver of Article 314 disclosure as States Exhibit 3, waiver of risk and need assessment as States Exhibit 4. State will also request defense counsel to stipulate in a venue and jurisdiction of this honorable court, and to also stipulate evidence has been filed sufficient to plead guilty.
Your Honor, on behalf of Ms. Vasquez, no objection. We so agree and stipulate to all the evidence and to the venue.
And without objection, so admitted. It will be the judgment of the court that Haley Vasquez is guilty as charged in CR 22-00331. Recommendation state?
Yes, Judge. The state recommend $200 fine, court costs, 1 year in Delaware County Jail, probate for 6 months, a law school course, and 20 community service hours.
And the 20 community hours. Okay, now court will hereby waive the community hours. And is that the understanding, Mr. Ortega?
Yes, it is, Your Honor.
All right, then that'll be the judgment. 200 plus court costs, 1 year in jail, suspended and placed on 6 months probation, I heard,
Yes, Judge.
Correct, Judge.
and the life skills. All right, that'll do it, Ms. Vasquez. Good luck with your probation, ma'am. Okay, you're excused.
Thank you. I appreciate it. Thank you.
Thank you, ma'am.
Thank,
Bye-bye.
thank you, Judge.
Yes, sir. You're excused. Thank you.
Bye-bye.
These two officers are the other two witnesses for the event.
Oh, that's right. Let me, we got some names here. Officer David, but okay, Officer Dan Gonzalez, Officer David Balboa, and Lieutenant Easton. Can you hear me? You need to,
They can unmute.
yeah, you can unmute, please. This was the bench one?
Okay, there we go.
Yes,
All right. Yes. Can you hear me?
Okay. Yes, yes. Thank you, ma'am. Good morning.
I'm assuming.
Good morning, Judge.
And what's your name, ma'am?
I'm Officer Gaona.
Oh, Gawana. Okay, we got you here on the list. And what's your name, sir?
I'm Officer Gonzalez.
And Gonzalez. There you go. We got him here. Earlier, we called the case and it didn't go because we're going to do a incompetency examination. So it didn't go. Thank you very much for waiting, for being available. And we'll let you know if we need you again in the future, okay?
Yes, sir.
Okay. Thank you so much, sir.
You'll have a great day and stay safe.
You too.
Bye-bye.
MTS.
MTS, Mr.
Number one.
Mr. Ortegon, right?
Yes.
Okay, let's see. Mr. Jorge Luis Ortegon. Good morning, sir.
Good morning, Your Honor. How you doing, sir?
Fine, fine. Thank you, sir. It's a motion to suppress, right, sir?
That is correct, Your Honor. And my client should be logged on, Judge. I just spoke to
Right.
him.
You're
There he is.
CR 1915-873D Eleazar Santana, right, sir? All right, there he is right there. Can you hear me, Mr. Santana?
Yes, sir. Loud and clear.
All right, there you go. And then state, Mr. Gwynn, you have a witness, right, sir? That'll be Trooper Joseph Mancias, right, sir?
That is correct, Judge.
All right, let me see. There's Trooper right there. Okay, I recognize him now. How you doing, Trooper?
He's muted.
Yeah, you need to unmute, Trooper.
There you go. Good morning.
All right, good morning. Good to see you again, sir. It'll be a motion to suppress here on cause number CR 1915-873D, Eleazar Santana. Mr. Gwynn, you may want to get it started, sir. Oh, wait a minute. Trooper, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you very much. You may put your hand down and state, you may begin.
Judge, before the state begins, we would like to ask defense counsel what exactly he's trying to suppress.
The stop and the arrest, Your Honor. The stop and the arrest.
Stop and the arrest. Okay. All right.
Trooper, can you please state your full name for the record?
Joseph Alexander Macias.
Okay. What police department do you currently serve?
I work for the Texas Department of Public Safety.
Okay. How long have you worked for the Texas Department of Public Safety?
Over 5 years.
Okay. I'll let you draw your attention to the night of October 13th, 2019. Where were you patrolling that night?
I was patrolling in Hidalgo County.
Okay. What city is that in?
It's in the state of Texas, around the McAllen area, McAllen Far area.
And was this a public place?
Yes, it was.
Okay. And while you were patrolling, did you observe anything out of the ordinary?
Just normal traffic and traffic violations and stuff like that.
Okay. What first drew your attention to the car?
Oh, it was a Ford pickup. I observed it. It changed lanes without putting its turn signal on.
There you go. Did the lane in which the defendant merged with the lane that he was coming into?
No, it did not.
Okay. What kind of car was this?
It was a Ford pickup.
Okay. And is this a motor vehicle?
That is correct.
And did you conduct a stop of this vehicle?
Yes, I did.
And where was this stop?
Well, he was on the frontage road, and then he pulled into a parking lot. So
Okay,
yeah. Are you asking
and,
where?
Yeah. Okay. What city was this in?
It was in the city of McAllen.
Okay. Was this in Hidalgo? What county was this in?
In Hidalgo County.
Was this in Texas?
Yes, it was.
And did you make contact with the driver?
Yes, I did.
Do you see the driver of that car on Zoom with us today?
I believe so.
Okay. For the record, can you please identify that person you recognize as the driver with the article of clothing?
How does this work? I think he's wearing a green shirt. I can't really see on my phone.
Okay, Your Honor, may the record reflect that the witness has identified the defendant?
He's in a blue room. I guess it's a better identifier. I'm not sure.
All right.
Okay. Now, once you make contact with the defendant, what observation did you make of the defendant?
Just that they were just observation of a scent of an alcoholic beverage emitting from the cabin of the vehicle.
Okay. Did you notice any odor on or about the defendant person?
Just whenever he spoke, the odor got stronger, and whenever he stopped speaking, it got a little bit weaker.
Okay. And can you describe the defendant's speech as he's speaking to you?
His speech was a bit slurred.
Okay. And did you notice anything else about the defendant?
Just that, I mean, his speech was slurred. It seemed a little. I guess that's about it. Yeah.
Okay. Did you ask the defendant have he been drinking?
Correct. I usually ask that in my sentence of questioning.
Okay. What did he say?
He said that he did. I believe he said that he did have something to drink.
Okay. Where was he drinking at?
I believe it was a brand of whiskey. I think it's called Buchanan's or something like that, around that nature.
Okay. How many drinks did he say he drank?
I think I don't think he gave me a direct number. It was around. I think he said an estimated number of 4 to 6.
Okay. And did you ask when did he drank?
Did I ask him? I think I asked him when the last time he ate was. I'm not sure if I asked him when the last time he drank was.
Okay. Did you ask the defendant to step out the car?
Correct.
Okay. Did you ask the defendant to perform the standard field sobriety test?
Yes, I did.
And are you certified to conduct a standard field sobriety test?
That's correct. I am certified.
Okay. And did the defendant indicate any medical condition that might prevent him from performing the standardized test?
No.
And did the defendant appear to be injured in any way?
No, he didn't appear to be injured.
Okay. And what was the first test that you had the defendant perform?
The first test is a horizontal gaze nystagmus test.
Okay. Were instructions given to the defendant on how to perform the test?
Correct.
And did the defendant indicate that he understood the instructions?
Yes.
And did the defendant attempt to perform the test?
Yes, he performed it.
Okay. And how did he perform on the test?
Well, I got 6 out of 6 clues on that test for
Okay.
the defendant.
And how many clues are possibly there?
There's 3 per eye, so 6 total.
Okay. And is the defendant's performance consistent with intoxication?
For that test, yes.
And what test did you have the defendant perform next?
The next was a walk and turn.
Okay. Were instructions given to the defendant on how to perform the test?
Yes, they were.
And did you demonstrate how to perform the test?
Yes, I did.
And did the defendant indicate that he understood the instructions?
Correct.
And did he perform the test?
He did perform the test.
And how did the defendant perform on that test?
That one had no clues.
Okay. What was the next test that you have the defendant perform?
The next test was a one-leg stand.
Okay. Were instructions given to the defendant on how to perform this test?
Yes, instructions were given.
Okay. Did the defendant demonstrate that? Did you demonstrate the test for the defendant?
Yes, I did.
And did the defendant indicate that he understood the instruction?
Correct.
Okay. And did the defendant perform the test? Attempt to perform?
Yes, he did.
And how did the defendant perform on the test?
He had the two out of 4 clues.
Okay. How many possible clues are there?
There's 4.
And how many clues did the defendant display? 2. Okay. And is this consistent performance consistent with someone that's intoxicated?
Yes, on the one-leg stand, the decision point is on at least 2 clues.
Okay. And also, what do you think of the defendant overall performance?
Well, the standardized field sobriety tests are based on clues, so the clues were in line with intoxication.
Trooper, with your years of training, experience, and observing and talking to the defendant, did you form an opinion that the defendant was under the influence of alcohol?
Yes.
And what was your opinion based off?
It was based off the totality of the circumstances as well as the standardized field sobriety tests.
Once you determined that the defendant was intoxicated, what did you do next?
Well, I offered him the opportunity to do the portable breath test.
And how did he perform on the portable breath test?
Well, he agreed, and then I believe he got a 0.13 on the portable breath test.
Judge, at this time, we would object to any testimony regarding the portable breath test, as the results on the portable breath test are not admissible in trial, Judge.
Okay. All right, then objection sustained.
Thank you, Your Honor.
Okay.
What happened next, Trooper?
Well, based on everything, he was placed under arrest for driving while intoxicated.
Okay. No further question, Judge.
Thank you, sir. Mr. Ortega.
Thank you, Your Honor. Trooper Jorge Ortegon, I represent Mr. Eleazar Santana. I'm going to ask you a series of questions. If you don't understand my question, or if there's any, if you need me to re-explain, do not hesitate to let me know that you need me to elaborate.
All right. Yes, sir.
Okay, so Trooper, you testified that that you came in contact with my my client on what night?
On the 13th of October.
Okay, and have you had the opportunity to review your report prior to today's hearing?
Yes, sir.
Okay, now is there anything you would like to add or exclude from that report at this time?
At this time, no.
Okay, so everything in your report would indicate what happened on that night. Is that correct?
That is correct.
Okay, Trooper, it indicates that you indicated that you did not ask my client when he started drinking and when his last drink was. Is that correct?
That's correct.
Okay, do you feel that it would have been important in your investigation to get a more, a more conclusive investigation to know how much and how and at what time they started drinking?
Yes.
Okay, but you failed to do that. Is that correct?
Correct.
Okay, also you indicated that my client had admitted to having drinking 4 to 6 Buchanans. Is that correct?
That is correct.
However, you didn't ask him how much of that Buchanans he had. Is that correct?
I don't believe so. I think I just asked him like how big the cups were that he drank out of.
Okay, so in your report, it's merely an estimate of what you would assume he would have drinking based off of his testimony. Is that correct?
That is correct, sir.
So the amount of alcohol indicated in the report would be an assumption on your part. Is that correct?
Correct.
Okay. So at this point, you're just assuming that my client had a certain amount and over what time he had that amount to drink. Is that correct?
That's correct. I have no way of knowing.
Okay. But you could have asked him more detailed questions. Is that correct?
Yeah, I could have asked him that.
Okay. Now, prior to, I guess, making a stop, I want to go back a little bit. You said that he failed to signal a lane change. Is that correct?
That is correct.
Okay. Did he almost cause an accident?
No.
Did he complete that lane change?
I don't believe so, because I turned my lights on, and then he went back to the middle lane.
Okay, so he actually did not fail to signal a lane change. Is that correct?
He did fail to signal a lane change.
Okay, but you just texted that he went, or you just stated that he went back into the middle lane. Could you elaborate on that?
Most of his truck went into the south lane, but I activated my lights, then he went back to the middle lane. He did not turn on his turn signal to switch lanes.
Okay.
Most of the truck went like the southmost lane, as in the video.
Okay, now where is that in the Texas? What would that be in the Texas Transportation Code?
I don't know. I'm not sure what you're asking.
What
like
I guess what?
Or what do you mean?
Yeah. What? So it's your testimony that that's a violation of the Texas Transportation Code. Is that correct?
Correct.
Are you able to, I guess, elaborate or explain what that is on the Texas Transportation Code, or where it is in the Texas Transportation Code?
It's in the traffic code book. In I believe it's 545.104.
And are you able to explain those elements to the court today?
Basically, they have to turn their turn signal on whenever they switch lanes.
Okay. Now let's go back to where we were, and that was regarding at that point you made contact with my client and you had interviewed him. There's no indication in your report that there was any sort of struggle with my client or he was unable to answer your questions.
Yeah, he was able to answer questions.
Was he able to get you all the information you needed?
Yeah, so the questions I asked, he was able to answer. That is correct.
Okay, and did you ask him for his license?
I should have. I don't remember. I can't recall. I would have to refresh my memory, but I do for the most part. Yes, I did ask.
But there would have been. But if there was anything out of the ordinary, you would have indicated that in your report. Is that correct?
That is correct.
So it's fair to say that there was no issues or nothing out of the ordinary between the time you made contact with my client to the time he started the standardized field sobriety test. Is that correct?
No, just what I had listed about the scent of an alcoholic beverage. That's the only thing out of the ordinary.
So that's all.
Normal. Yeah, that's correct.
So was my client, did he have slurred speech?
What I felt was slurred compared to normal.
Okay, was he swaying while walking or any sort of issues like that before you started the standardized field sobriety tests?
Well, just from what I see as normal, he was walking a little bit different. Other than that, I mean, I don't really know him, so that's just based off normal interactions with people.
But that's not indicated in your report, is that correct?
Probably not. It's indicated in the other sheet, in the DIC sheet.
Okay, but you stated that you wouldn't have wanted to add or change anything to your report. Is that correct?
That's correct. I figured at that point, what's part of the DIC sheet is considered part of the exhibits in the evidence. That was back in 2019.
Okay, by the DIC sheet, you mean the DWI interview sheet?
It's the one that has the forms that say how many papers in there, and it says it's a DIC, I think the 24 or 25. But just a misunderstanding on my part back then. That I assumed that was part of the whole report exhibit process.
Okay, so the DIC 24 would be the statutory warning, and the DIC 25 would be the notice of suspension. So would you agree with me if I say that it's not indicated in that at all?
There's a form. I can't recall what form it is. It says maybe I'll say what form it is, but there's a form in the whole sheet, the packet that has that in there. But you are correct in
Would be
saying
the
that it's not in the
DWI.
report.
Okay.
You are
Now you gave my client the 3 standardized field sobriety tests. Is that correct?
That is correct, sir.
However, you indicated earlier in testimony with the DA that you did not observe my client to have any injuries. Is that correct?
That is correct.
Oh, and he didn't seem to have any physical limitations. Is that correct?
That's correct.
However, nowhere in your report does it state whether or not you asked him if he had any physical or mental limitations to take this test. Is that correct?
That's correct.
Do you believe that you should have asked him if he had any sort of issues or anything that could have prevented him from properly taking the standardized field sobriety tests?
Yeah, I could have asked him.
But you failed to do so. Is that correct?
No, I didn't. I didn't ask him.
So you failed to ask him. Is that correct?
Correct. I didn't ask him.
Okay. And you also indicated that my client actually did not show any clues on the walk-in turn. Is that correct?
That is correct.
Now, the horizontal gaze nystagmus, there would be no way of knowing how he performed on that test in a jury trial. Is that correct?
Just my testimony.
But you're the only one who would actually know how he performed on that test. Is that correct?
That's correct. There's no technology for that. That's correct.
Okay, and then the other 2 tests would be determined. The other 2, the walk-in turn and the one-leg stand, would be indicated in the that would be able to be seen in a video. His performance. Is that correct?
That is correct.
And one of those tests he actually did pass, as per your testimony.
It's not I'm sorry. It's not a pass or fail test. It's based on clues.
But he did not reach the minimum amount of clues to have,
correct.
Okay, the minimum amount of clues. He didn't show any clues.
Correct.
So if this honorable court were to review the video, they would have an opportunity to see how my client performed on that test. Is that correct?
That's correct.
But this honorable court would never be able to see how he performed on the standardized field, on the horizontal gaze nystagmus.
That's correct.
And at that point, you gave my client the PBT, the portable breath test. Is that correct?
Yes, I gave him the opportunity to take
Okay.
it.
Okay. And when was the last time you had calibrated that test, the portable breath test?
The PBT is when was it? I think it was around 2018.
Okay. So there's an opportunity there's a chance that could have been unreliable.
You would have to testimony an expert witness in regards to how the portable breath test works, how it functions.
So you relied on the portable breath test that was not completed by yourself. Is that correct?
I don't rely on it. In order, the rest of this decision was made before the portable breath test.
Okay. Okay. So the decision to arrest was made before the portable breath test is your testimony.
The portable breath test is just to determine if the intoxication is due to alcohol or due to another thing in their system. It's not, our arrest decision is not based on the portable breath test.
Okay. Judge, at this time, I pass the witness.
All right. Thank you, sir. Mr. Gwynn?
Yes, Trooper, you said that you didn't ask the defendant when his last drink was. Is that, why is that not relevant to you forming your opinion on whether he was intoxicated or not?
That's more to get an estimate of when his last drink was. I mean, I could have asked him that, but I didn't. I just forgot.
No further question, Judge.
All right. So So gentlemen, there's a video out there, right?
Yes, Judge.
That is
Alright,
correct,
then-
Your Honor. We would
then
ask
the-
that it be submitted for this honorable court's review.
Okay, so then no more questions, Mr. Ortega?
No, not on my end, Your Honor.
All right, then you're not gonna have a witness, right, Mr. Ortega?
No witness.
Okay, then court will at this time go ahead and take this matter under advisement. We'll consider the evidence heard today, and of course, we'll look at the video that is that pertains to this case. Trooper Macias, thank you so much for your testimony. You're excused. You have a great day, okay, sir?
You too. Thank you, Your Honor.
Thank you. Bye-bye.
Thank you, Trooper. That's all I have at this time, Judge. May my client and I be excused, Your
You
Honor?
and your client may be excused, and that'll do it, state. Court, like I said, will take that under advisement, and we'll review